Hi, this is Rain. Sounds like Green. I'm a Minnesota realtor helping families get through probate with more money and less stress. And today I'm joined by Minnesota attorney Kate Smith-Thompson from KST Law. Kate specializes in making estate planning and probate navigation accessible to every family with a focus on affordable and legal services, including a flat fee rate option plan. Kate, welcome to the Probate Help Desk podcast. Tell us a little bit about your practice and what drew you into probate and estate planning work.
Hi, Reen. Thanks. So I got drawn into estate planning and probate a little by accident. I have a background in financial services, and when I decided to leave the corporate world, I knew enough about that world to understand that that has a direct effect on people as they exit this world. I also find that probate is a fascinating area of law because you need to know a little bit about a lot. You need to know a little real estate. You need to know a little bit of civil law. You need to know family law, and you certainly need to know tax and other specific things. So it really is a nice, challenging area of law for me. I'm also drawn to, and my motto is law for everyday people. I felt that there was a niche in educating just about everybody that they have something that's worth protecting. And so the estate planning side of that comes out of the idea that everyone has something to protect and that I can help them do that. This is not just for rich people or people who have a ton of earthly assets. Everybody has a soul and a heart and health that's worth protecting. Everybody has a little something that they can take pride in and leave beyond memories.
Oh, that is fantastic. And one of the topics that I want to start out with, I think almost kind of really fits that philosophy, and it's the small estate affidavits.
Yes.
And as a realtor, I get a lot of questions, people who maybe someone has passed away and they want to try to avoid probate. And sometimes probate might not be necessary. There are other options, and some people don't realize that there are other options, and small estate affidavits is one of them. And so, when you talk about making probate affordable and accessible and dealing with people at all levels of wealth, could you talk a little bit about how small estate affidavits fit in and how you use them with your clients?
Sure. So the small estate affidavit is a wonderful tool that we have in Minnesota. It allows for a personal representative or a next of kin, actually, if someone doesn't have a will, to wait 30 days after the unfortunate passing of a loved one, and then to be able to fill out this particular affidavit and have it notarized and to state, I am the next of kin, and probate is not necessary in this particular decedent's case. And there's a few ways we can use it. And that actually that affidavit will allow that next of kin to go collect assets. That would be things like closing out a bank account, collecting any monies owed or due, and potentially transferring a car title or something along that line, something small.
Mhm.
The other thing that they can do is collect things like a security deposit on an apartment. So the small estate affidavit is applicable if the your loved one had less than $75,000 in assets total. Okay.
Mhm.
So we are talking very small estates and even medium estates. Some people have a lot of money in the bank and you don't realize it until you get to the bank and realize how much they have. So, and these are things that don't have a beneficiary attached. And we can talk about some probate avoidance tactics that are actually free and
Mhm.
very accessible and available to everyone. But primarily with the affidavit, when we prepare one, we're waiting 30 days after the death. We're collecting a death certificate. And then when I prepare the affidavit, I'm going to prepare it in the name of one person who is the appointed representative on earth for our
Mhm.
decedent. And I'm going to be as specific as I can be about it because I'm going to say we're going to collect accounts at XYZ Bank. We're
Oh,
going to transfer the title of a 1995 Chevy Caprice with this particular VIN number. We're going to be
mhm.
very, very specific about those assets simply because if it's too broad, somebody who holds those assets may not accept it. If it's too narrow, then it may not be accepted at all places. So 30 days also gives us the opportunity to do something of an inventory, collect, get an idea of what this person's life on on earth and on paper looked like, and then we can go ahead and prepare that affidavit in the best way possible. I will also tell you that the affidavit cannot be used if that person owned real estate
Mhm.
in any way, shape, or form. So if we go ahead and collect assets, and then we find out that they had a partial ownership in, say, a cabin, or or owned a house with two other people, and there's some form of real estate ownership there in single title or potentially even a tenancy in common, which is, a very real thing, or they inherited something and forgot about it, then we may end up having to go to probate court over and above the small estate affidavit. But that's a great handy tool for someone who doesn't own real estate and has a very small estate where probate is just not economically necessary.
That is fantastic. And I should also mention for some of our viewers around the country, Kate and I are both in Minnesota, and this is a tool that we use in Minnesota. And you mentioned the threshold of $75,000. Some of the attorneys that I've talked to across the United States have also mentioned that they have something similar in their states, and sometimes it might be called something a little bit different, or the threshold in each state might vary. But but this is a tool that seems to be a similar tool seems to be available in a lot of states. So if
It's
you're not,
growing it. Yeah,
yeah,
it's growing in popularity, Reen, for sure. And I spoke to an attorney in South Carolina who I actually worked on. We had a co-client, which was fantastic. It was a lot of fun to work with. It's always fun to work with my colleagues across the country. But in this particular instance, he explained to me that they do have the same sort of process. They call it something different, but their threshold, I believe, in South Carolina was like
right,
$25,000, which, to be honest, is not that hard to get to in this day and age.
yeah,
For some people that sounds like a king's ransom. For others, it's a drop in the bucket. So yes, specifically for Minnesota, those are our two probate triggers. In some states, particularly in New England or in places where they were closer to what I would call sort of the king's law they were colonies, there may be more antiquated laws on the books where everybody's required to go to probate no matter what. You have to take the will, register it, and then sometimes all it is a rubber stamp and a letter that says this is this person and they can go take care of stuff. In some situations, we do the small claim affidavit. And I believe in Minnesota, the reason we do it is because the court doesn't want to see you unless they absolutely have to.
okay. Now, yeah, we don't
But
want
it's
to
a
clog up
great
the court.
tool. And for an hour of an attorney's time, it's absolutely worthwhile to be able to collect assets from someone. Otherwise, they go to unclaimed property and then who knows?
Well, and those are two really common questions, right? One that I hear, and probably you do too, is how do we change the title on that vehicle? We don't
Sure.
have real estate. How do we transfer title on that
Sure.
vehicle? Or I
Yeah.
went to the bank and they froze the account. Now what do I do? You know?
Mm-hmm. Very, very common. So with the freezing of the bank account, like that's something that I run up on with my clients all the time. They were notified of the death, Social Security now knows about the death, and now all of a sudden the account's frozen. Right, they're going to freeze it for 30 days because they're going to need to double check to make sure that there's not a Social Security clawback. Social Security is going to need to, if they were on Social Security benefits, whether it was retirement, SSI, SSA, whatever, survivor, whatever it was, they're going to freeze it because Social Security is going to want to do an analysis to determine whether or not there's a clawback. And then they're
Hmm.
going to want to, they used to automatically do the death benefit, but I'm hearing lately with some of the bureaucratic changes that are happening in Washington right now. And for reference, it's April of 2025. So lots is happening right now. And essentially, I'm hearing that now we are going to have to go back to applying for that death benefit, which is a total of, I think, $255 right now. It used to be that they would claw it back, leave the death benefit in the account, and just move forward with life. Not sure how that is. So that would be best to check with the Social Security Administration for everybody's individual circumstance.
That's interesting. What I was going to ask is, if the bank does freeze the account, is Social Security still able to get in and claw back
Yeah,
the
they
benefit?
have power.
Yeah.
I believe that's the one exemption that they're able to go in and notify, and I think the bank might have to authorize it, but I've never known a situation where the bank didn't authorize Social Security to claw something back.
Interesting.
Yeah.
Interesting.
No, also that's another thing you to expect. You're going to expect bounce checks. If there's somebody who's still writing checks on the account, if there's automatic withdrawals, those are going to start getting rejected.
Mhm.
When you go in to collect a bank account under a small claim or small estate affidavit, ask the banker to waive all those fees.
Yes, yeah,
and to
absolutely.
double check everything because you shouldn't have to pay those fees just because somebody passed away. Of course, those things bounced and you're not sure what's going on, but you can go back and repay those things as you see they are necessary.
Hmm.
So, and then as far as you were asking about the DMV, it's really simple. In Minnesota, we have all of our forms online. We've made it extremely easy to find. All you need to go do is go to the Minnesota DMV website, and the forms for transferring under non-probate are right there. You can fill it
Oh,
out, email it, fill it in. I think you can just make an appointment at the DMV, take the title, the death certificate, your identification and the correct paperwork, and of course your fee, and the DMV will transfer it. They're very used to it, and it's a very streamlined process. And that goes for mobile homes too. Anything that has a DMV title can be
mm-hmm.
done in that same process.
Yeah, and that's one of the questions that comes up for us on the real estate side a lot is someone had a mobile home registered through the DMV and maybe they had title on the land or maybe the mobile home is sitting on somebody else's.
Yep.
And then you
Um,
add probate into the mix and it gets
right.
interesting.
Some of that turns to on if you're paying in the situation of a mobile home, are you paying lot rent or is the mobile home sitting on your property? If it's
Hmm.
sitting on your property, we do have may have a probate issue because you might own that land. That's interest in real estate. We got to look at what that title looks like. And again, what I said back, a few minutes ago, if that's land and you own it or the decedent owned it, then we may find ourselves in probate due to owning real estate. If it's lot rent and all we're doing is transferring the title to the actual mobile home,
Yeah.
then we may or may not need that. We may be able to do it under those DMV papers and with the small affidavit.
Yeah, you and I were talking earlier about when do we refer work out? And typically if there is a mobile home involved, I will usually bring in one of my colleagues who's an expert in mobile homes. I've done a few transactions myself, just enough to realize it's better for me to have help. And a lot of times we'll just partner up, and I'll work with them on the probate side, and the attorney work with them and the attorney on the probate, and then we have someone
Yeah.
that knows how to do those
But
transactions.
DMV titles can be moved by a personal rep or next of kin. And one of the free things that you can do to prevent probate is to actually put a TOD endorsement on your title. So anything that has a title can be put. You can put an endorsement or a transfer on death.
Mm-hmm.
Functions like a beneficiary. So if you know you want somebody to have your car, go ahead and do that on your title. Pay a little fee and they'll put the endorsement on it. And you can say, so and so gets my car. Green, I'm
Right.
gonna leave you my Corvette, you know?
Nice.
And then it passes. And the nice thing too is that no matter what the value is on that vehicle, it will pass free of probate because you've designated a beneficiary. Probate assets, generally speaking, are only those that we don't know where they go.
Mm,
But if we can answer the question, who gets this thing, then that's generally a non-probatable asset.
absolutely. So if you're doing something like a transfer on death at the DMV, I know
Mhm.
they have that option with the banks as well, but I don't, or go ahead.
Banks are called for the bank account, it would be called a POD. So that's a
You're right.
payable on death. And again, it's an endorsement. It's this person gets my account when I die. And the best practice there that I've seen is to go ahead and do your estate planning and name your personal representative. It's someone we used to call the executor. We now just call everybody personal rep in Minnesota. But you would name that person as the beneficiary of your account. So whatever's in your account, you can take the death certificate and your ID, set up an appointment with the banker, go in, and they will close out the account and issue the funds to that person. This does
Hmm.
two things. Number one, if you do have to go through probate, that's the foundation of your estate account. You're going to want to hold that money until you're nominated as personal representative. Or you should use that money to immediately begin paying bills and expenses. Funeral expenses can be paid out of that, costs of administration, but you should receipt those items. So if you start paying out on those, keep a log, keep an accounting, because that's considered a state expense, right? The other thing to say is, or that can be the foundation of an estate account. Once you're nominated as a personal representative, if you are going through probate, you'll want to start a state account. You'll want to open an estate account with that bank. Use that money as your initial deposit because if there is a sale of real estate or if there is any money coming into the estate, it needs to go into the estate account for proper accounting and then it can be distributed.
Sure.
Another thing to say too, and I get really long-winded about this, but it's just like lots of these little tips and tricks and hints, right? Um, if you own a bank account that is co-owned, a lot of older folks, they say they'll put their son or daughter on the account with them if they are, widowed, um, or are single, but they'll put a co-owner on the account so that they can write checks and help them pay bills. Very often it's someone who holds a power of attorney.
Right.
Um, if that account is co-owned, it will not be frozen
Oh,
and
yeah.
it will not be held. And whoever co-owns the account, that money it becomes their money.
Hmm.
So it's handy because at that point, yes, you can still use nothing changes because it's co-owned. But I will say that it should still be, and it's actually out of probate, so it's not even accounted for. Now, hopefully, that's not the bulk of the estate. Hopefully, there's not a ton of money there, and people aren't expecting checks. And also, hopefully, whoever the co-owner is isn't going to make off like a bandit,
Hmm.
because there's no legal recourse there. That is legally their money.
Right.
It's up to them to do the right thing and to abide by the deceased loved one's wishes.
Absolutely. So you've you're providing so much information.
I'm
I'm
sorry.
coming up. No, no, that's what we want. I'm coming up with questions, and
Good.
I'm thinking about your service offering, and some of what we talked about at the beginning was making these services available to families of all levels of wealth and income.
Absolutely.
And then also we talked a little bit, or I mentioned that you offer flat fee services. And so one of the questions that just occurred to me is someone who might have a very small estate,
Hmm.
and they think that they could do it themselves. Maybe they think there's not much there. There's no real estate. And you talked about the small estate affidavit as a tool, but I was just thinking, just coming in and spending an hour with you would save a personal representative so much time and headache and probably money too.
Hmm.
Do you, is a flat fee service offering something that you offer to a family who might have a small estate or an estate that doesn't have real estate, or is it, how do you, like, I'm
How do
almost
I?
thinking you could like that's almost a service you could promote if
It
you're not
is.
already. Yeah.
I've actually had clients who, very often what will happen is I'll get a phone call and somebody will say, we've had a death in the family, and we need to know if we need to do probate.
Hmm.
And my first question, my first answer, of course, is I'm so sorry for your loss. Because no matter what, we're dealing with loss of human life, there's grief. And no matter the circumstances, it's important to approach with humanity and compassion, right? So my first words are always, I'm so sorry for your loss. The second question that I have for everybody is, have you had the memorial service yet? Have you had a funeral or a celebration of life? Where are you at in that process? And when did they pass away? And if the answer is mom died Monday and the funeral is next week,
Hmm.
my immediate answer is let's put an appointment in the books for a couple of weeks from now because I can't do anything without a death certificate. And I want you to get through the process of that end of life ritual, whatever it looks like for your family. Even if there's no formal service, you should wait until the death certificate is issued, you've picked up ashes or you've disposed of whatever, or arrangements have been made somehow to wind up that person's bodily remains, right? It's really important to pace that out. Now, there's stuff you can do in the interim. So let's talk about what happens then. They'll make an appointment with me, and I do what I call a probate consultation.
Hmm.
And I do charge for those, but if you hire me and it's discovered that we need probate, I waive that consultation fee because you're going to pay me a retainer and an hourly fee anyway. And I now know enough about your case to be comfortable taking it and to understand, to give you a quote on what I feel like this probate may take, and then be able to offer a retainer accordingly, right?
Perfect.
If we decide that we don't need probate, or if we just need a consultation, I'll ask for 1 hour of my time as a consultation fee. I will leave a list of things that they can do. And very often I will offer what I do call consultations. So I have clients who will call me and say, I don't think we need full probate, but if I have a question about something, what can we do? I will sign a limited client consulting agreement, and they can buy an hour of my time a la carte whenever it's needed. And I can make myself available for consultation upon payment of like an hour or two, or if it's something like, can you review this before I submit it?
Right.
Absolutely. But what I will not do is become an attorney of record. I will not sign a certificate of representation. I will not prepare court documents or submit them, and I will not appear in court on your behalf. And also, the idea of a consultation or a consultative approach makes the idea of attorney-client privilege a little bit more gray area. So I never guarantee privilege or confidentiality. Yes, it may not rise to the ethical level of privilege. So I'm always very careful to caution anybody who wants me just for an hour of my time or for a consultation basis that they will not enjoy those things with me unless we go full representation. But most of the time they don't need it.
Right. And that is really, it's nice to have that option because then
Absolutely.
you can sit down with your attorney with no pressure, or not your attorney yet, but you can sit down with an attorney with no pressure and really talk about whether you need to do this or don't, and what
Yeah.
would you do.
The
And
other,
that avoids a lot of
yeah,
those mistakes that we see people make.
absolutely. The other thing to know is, especially for Minnesota, we have a 3-year statute of limitation on probate. You have 3 years from the date of death of your loved one to file a probate claim or a petition for probate or a personal representative. And even after 3 years, we have a declaration of descent
Hmm.
process whereby we can declare somebody the next of kin. There's no personal representative, and it's treated a little bit differently, but it is a process if you happen to find assets that you didn't know were there before, or if you discover a death that happened a long time ago. There are many, many reasons why you might want to use a declaration of descent, or,
Hmm.
if it's been over 3 years. So, but yeah, we have 3 years to do this. So, people are really worried that they need to be in court right away. And the answer to that is you're not going to be in court more than 30 days after the death, you know. And even then, it's going to take a little time to get all the paperwork and get everything together, determine what type of process you need, find an attorney, you're fine. But there are things that you can do in the interim that protect the assets and that will help. And that's where I find a lot of families have pitfalls.
Okay. Well, and that was going to be my next question. I was going to ask, what are some of the common mistakes you see families make, especially maybe it's with the small estate affidavit, maybe it's just probate in general, but what are some of the mistakes that you typically see?
And one of the things I see is people jumping the gun. That's
Mm-hmm.
something that's really, really important not to do.
That
Um,
impacts us on our side too.
yeah, and one of the things that I hear,
Hmm.
I recently had a situation with a wonderful client. I actually got a call from their realtor,
Hmm.
and the realtor said, well, they're dealing with a death. They want to sign the house, sell the house. We've got, I've got pre-market buyers. Very, very, very good realtor, incredibly good. But they didn't, they were from out of town,
Hmm.
and the client called me and um, she said, well, I have the will, and I'm the one I'm named as
Yeah.
a personal rep. Am I good?
Yeah.
And the answer is, if you're a realtor and you sign a listing agreement based on a will that says somebody is the personal rep, you are putting your license in danger because
Hmm.
there is nothing definitive and the court has not ordered who the personal rep is. And only a personal rep can sign a lease or sign a listing agreement or sign a purchase agreement or close on an estate property. So we had to walk that through and talk through what the process was for Minnesota. Now, fortunately, so that's the idea. Obviously everybody wants to hit the spring market and, get going with that house and get that house sold. It's going to take you a little while to sell the house. So my first advice is gather funds and make sure that you can cover some basic bills and expenses. My second piece of advice is there's a tendency or the idea that everyone's in town for the funeral and everyone's going to go to grandma's house and take what they want, right?
Hmm.
And then you
Hmm.
also hear the horror stories where somebody tells Uncle Joe to sneak out of the back of the funeral, run to grandma's with the pickup truck and pick up that china closet because God knows who's going to get it if I don't get it first.
Yep.
Don't do that.
Yeah.
When you have, and it's really hard to remember to do these things in the first 24 or 48 hours. So these are things that you can even do. If you have a loved one on hospice, or if you know somebody hasn't been in their home for quite some time, it can be as simple as doing a basic inventory and just taking pictures inside each room to determine what was in the house, because what was in the house at the date of death is what's considered the inventory. You don't have to get super granular. You don't have to say grandma had 6 knitted sweaters and 4 blankets and yada yada. But what
Mm,
you can say is normal wearing apparel. She had a collection of vintage vinyl records. There was an antique phonograph. She had china, she had some of these other things. So before everybody comes in and takes everything, make sure you have something of an inventory of the contents. And then if you do allow people to take tangible property,
mm,
um, keep a list. You don't have to receipt. It doesn't have to be formal, but keep a list of things that people took, because there's sentimental things and then there's things that are worth value, right? And the sentimental things are totally okay. Somebody wants grandma's scrapbook, okay. Cousin Joe took the scrapbook.
right.
Um, cousin Tina needs she needs a coffee table, so she's gonna come get the coffee table, and we're gonna put that. She had this really cool painting on the wall that she got on a cruise ship in 1965 or whatever it was, right? Those are totally okay to distribute, but you need to keep unless it's a fine art or something that may be worth a lot of money. Coin collections, those need to be treated separately because they're actually considered currency. So those
Oh,
need to be appraised.
okay.
Those are things that are strange. But some of the normal stuff, that all needs to just be sort of inventoried before everybody comes in and raids the house. Um, if grandma, one of the things I always recommend, if grandma was the type to give a key to the house to everybody,
Hmm.
go ahead and get the locks changed. That's an
Yep.
expensive administration. You can get that reimbursed. It's $300, but it's no fun.
Hmm.
If it was a renter, if you can't change the lock, work with the property manager to find out how best to secure that property until it can be properly inventoried and emptied appropriately.
Absolutely. And one of the things I throw into that mix as well, that we discuss with the personal representative and their attorney, and also is it properly insured with the decedent not being there, and homeowners policy might have a clause related to vacant property. And so,
Absolutely. When you're notifying people of death, the insurance agent is absolutely a call that should be made.
mhm,
Um, and most of the time they're more than happy to say, yes, the homeowner's insurance is intact. It's been paid up for the next 6 months. We're not going to do anything with it
mhm,
because they're just going to let it be. If it takes longer than 6 months, or if there's a renewal that happens, you need to work with the insurance agent to make sure that that house is covered, because if it's an estate property and there's a casualty of fire, whatever, that
mhm.
needs to be able to be covered. And that actually, there's a special situation for transfer on death deeds that we should talk about when we get to that point and it comes to insurance, because there was a big change in the legislation last year. But the point of the matter is that, and also if you're in a townhome or a condo and there's exterior coverage, you should notify the homeowners association or the condo association. Let them know, because that may have implications for their insurance.
Exactly. Exactly. And I'm always amazed how many of my peers and even family members just don't ask that question. They just take it for granted, right? It's
And this is where good legal counsel can come in mind, because one of the things I do for my clients is I give them a checklist.
nice.
And honestly, if you're an estate planning client, I'm going to give you this checklist anyway, because it's good to keep with your estate planning documents. Hopefully these are things, and again, these are things that I don't get to tell people until it's too late.
Right.
Um, Likewise, another thing to remember is, we all, something like 98% of us in America have one of these, right? Even old people have the jitterbug or the cell phone. Make sure, if someone's on hospice, make sure that the phone is unlocked, or if it's locked, then see if there's a way to get it opened or whatever, because there's digital data, right?
Right.
That phone
Right.
may need to be returned, may need to be wiped. There's maybe photos on there that you want. You need to be
Mm,
able to know how to deal with someone's digital devices.
right. Absolutely. And a lot of times those digital devices also might leave some clues regarding the debts and the expenses and
Absolutely.
digital
Everybody has a
banking.
bank app, right? Somebody,
Uh-huh.
even if they
Yep.
don't have a bank app, they might have Chime or Venmo or PayPal or Cash App. There might be money and assets sitting out there that you need to figure out how to get to and in what amount. So.
Absolutely. Absolutely.
And interestingly enough, that goes to a power of attorney. The powers of attorney that I have, I do a short form, but we have a digital directive that we've added to our powers of attorney in Minnesota, which provide for a power of attorney during a lifetime. So when somebody is incapacitated in life and needs someone to take over, that power of attorney can, in fact, go and get a phone unlocked or handle digital data or enter emails or do things like that without fear of fraud or breaking the law. Because really, we don't want to jailbreak a phone if we don't absolutely have to.
Oh, that's fantastic. That's fantastic. And
And
so
so
you've
anyone who's like my young people's program, anyone who needs a power of attorney, I make sure that digital directive is there because if they have nothing else, they have a phone.
right, right. Absolutely. You've been sharing some of the do's and don'ts of probate. You've talked about some of the things to do before probate, and you talked about some of the things to do right after I'm sorry, before probate, but you also talked about what to do after somebody passes.
Hmm.
What about the debts and expenses? What are some tips you have related to debt and expenses, especially
That
before accessing a loved one's funds?
well, the first thing I'll say is don't pay anything unless you absolutely feel like you have to.
Mm-hmm.
One of the most wonderful things that you can do for yourself because people worry so much about how to pay bills and how to clean up a financial life. And whether it's a cleanup or a wind down or somebody left a mess or whatever, there are ways to go about it. If you have extreme debt, if your loved one had a lot of debt, filing probate may actually be in their best interest simply because you can declare that estate insolvent. And then
Mm-hmm.
you have as the personal representative the ability to write a letter that says the court found this estate insolvent. You are not getting your bill paid. And
Nice.
then it's conclusive.
Mm-hmm.
In Minnesota, after a death, we have a priority of debt. And this is in the statutes. And some people hear priority and they think first come, first serve. And in
Mm-hmm.
Minnesota, that's not the case. It's priority based on the type of debt. So your first priority that will always be paid are expenses of last illness,
Mm-hmm.
and funeral expenses. So those can be paid no matter what. And if you need to keep the utilities on at the house, like, pay your Excel Energy bill, pay your CenterPoint, pay your co-op or whatever it is, pay your city bill so that the waste and the water stays on because that's important to preserve the house for later sale, probably.
Right.
Okay. The second thing that's priority are both federal income tax and federal what we call federally I forget the exact word, but federally preferred debts and expenses.
Mm-hmm.
So that would be like your IRS taxes, your Fed taxes. And then that also includes you're going to want to do your loved one's last income tax. So for this year, it's April 10th in 5 days. If you're close to the deadline and they died last year, if they died this year, you have until April 15th of next year, and you're just going to have to do that at the end of the estate. If they're close or if it's the end of last year, go ahead and file an extension and then hire a bookkeeper and accountant to gather all the paperwork and do that last income tax return for your
Right.
loved one. And there's a place on that income tax return to check deceased and whatever, so that they don't worry about it next year. The main thing to remember is you don't have to pay your loved one's credit card bills. You do not have to pay their mortgage, actually. What you should do is provide a copy of the death certificate to the mortgage company and inform them that that person has died. There is a personal representative, and so if you have a piece of property and it may or may not go to probate, if it doesn't need to go to probate, that's fine. You still want to inform the mortgage company because what they will do is they will freeze it.
Mm-hmm.
They will not, if you miss payments, they won't flag it for foreclosure.
Okay.
Okay. Also, if you have a house that may be in pre-foreclosure or may have, if they've started foreclosure proceedings and someone passes away, you want to inform, if you can find out about it, you want to inform the mortgage company, but you also want to inform the court that that person has passed away. And those proceedings will generally cease they won't withdraw them, but they'll hold them or they'll put a continuance on them because it's actually more economical for the mortgage company to let the probate run, sell the
Hmm.
property, and then the mortgage gets redeemed, right? Much easier to do it that way than to go through the expense of a foreclosure proceeding. Some people want to just let it fall to foreclosure, and that's entirely the choice of the family. But if you can sell it and redeem some of that equity, you don't want to leave that on the table if you don't have to. And the market has been really good recently. So even if there is a foreclosure, if the house isn't mortgaged to the hilt, it may
Yep.
as well just go ahead and run it through probate and get it done,
So
right?
I want to jump in. Can I jump in with a question
Sorry.
on this? This
Yeah, go right
so
ahead.
this topic is a hot topic. We get asked
Mhm.
this all the time. So um, first question on working with the bank to avoid foreclosure. Would you
Mhm.
recommend that the family get their letters of administration or letters testamentary first and then contact the bank, or just contact the bank right away?
Contact the mortgage company right away, whoever owns that loan. Um, and that should be fairly evident if you can find a mortgage statement or closing documents, or even if you can't find any of that, if it's all electronic, you can go to the county recorder's office and there will be a copy of that mortgage on file if it's still
Hmm.
valid. So you can find out who owns that mortgage on that house right away, and then you can contact them and very often and just call them, and then they'll probably connect you with their estate care team or their probate team or whoever, but they'll note that file so that they can know, okay, if there's no automatic money coming out anymore for the mortgage, then we know why.
Right.
And then
Okay.
what they'll do is they'll also prepare an if they're doing an escrow for property taxes and homeowners, they can prepare an escrow statement. They can determine whether or not that needs, property taxes need to be paid or whatever. But the mortgage companies are very commonly okay with, especially if it's current, if the mortgage is performing in current,
Hmm.
they're usually okay with freezing it in the case of a death because they know if it's going to probate, they will get paid eventually.
Okay.
Interest may still accrue, but not a ton.
Yeah.
And even so, they just want to know what's going on because if you keep missing payments,
Right.
they don't want to send you into foreclosure on, they don't want to foreclose on an estate. It just doesn't work really well. So let me get back to like priority of claims, right? I got distracted with the
Yeah.
mortgage. So we have expenses of last illness and funeral expenses. We have costs of administration,
Hmm.
which is anything involving paying the personal representative any bills and expenses that need to be reimbursed, and actually attorney's fees.
Hmm.
We get paid first, which is kind of
Hmm.
nice. And then your federal ones, then there's more secured debt, your state taxes and your property tax. Like, at the very, very bottom of the priority list is your unsecured consumer debt. So that's your credit cards. Okay. They are so low priority. I don't want, and the worst thing is that the very often if they start missing payments, which they will, they'll get notified of the death via publication or via Social Security or via the credit bureaus. Once the Social Security number is reported as being dead,
Hmm.
it spreads like wildfire. Then all of a sudden you start getting notices from a collections agency, and it's a debt collections agency, and there's three or four of them that are that concentrate solely on estate recovery,
Hmm.
right? Um, and they'll start sending you notices, and it'll say, "We're very sorry for your loss. Please contact us." So then you call them, and they'll say, "Well, so we have your grandma's Discover card, and she had
Yep.
a bill of $6,000. How would you like to take care of that?"
Hmm.
And my number one piece of advice is don't pay that credit card bill
Right.
because it does, we in the US, we do not inherit debt and we
Hmm.
are not responsible for anyone else's debt. It doesn't hurt anything to not pay that debt because it's just going to the credit collection agency anyway. Your loved one no longer needs their credit score.
Right. Right.
And it
Right.
doesn't affect you as the personal rep or anything. So we don't inherit it. It doesn't affect you. So just don't pay it
Hmm.
because we will figure out what they are owed by law once we shake out the estate.
So that piece of advice right there can save somebody
Thousands.
the cost of attorney fees in
And the
some
credit
cases.
collection
Yeah.
agencies love it. Now, mind you, it is highly illegal to do this. But
Hmm.
the way that and they're not supposed to do this, and we've had some consumer reform, especially in Minnesota, but the way they come across occasionally
Hmm.
is how do you plan to deal with this
Right.
debt?
Right.
And the answer is you aren't responsible. It is for the estate to deal with.
Mm-hmm.
So don't pay it. Right?
That
If I can
is
if I can preach one thing, don't pay anybody's bill. Just don't pay, stop paying their bills. It's not going to affect you and they no longer need their credit card score. We will deal with it on the back end. So,
that is fantastic advice. Um, Kate, if you don't mind, I'm going to jump into one or two questions from our Facebook community.
yeah, please
And
do.
I'm already thinking there might be an invitation for you to come back and do
I'd love
another.
to. We haven't even talked about transfer on death deed yet.
But you've been providing great information, and I always say that I learn something new in every episode, and I've learned a lot in this episode. In fact,
Great. I'm glad I can be of
you
service,
gave me one
Reen.
tip that I need to change something I'm doing. I don't want to broadcast it in front of the whole world, but it was thank you for that advice. Um, all right, so first question from our Facebook community, and let's see here. I'm going to jump down. So this kind of ties in with what you were talking about with the finance. Um, can a personal representative borrow from an estate to provide advances to heirs before probate is complete?
Okay. Great question. Uh, the answer, of course, is the lawyer's favorite answer, which is it depends.
Mm-hmm. Mm-hmm.
Um, Theoretically, yes, that's permissible, but there's a couple of processes that need to happen with that. Number one, you need to have, it's essentially the personal representative's purview whether or not to allow that. And
Okay.
I would say it would require a thorough investigation of the assets and what that person may be entitled to under the will or under intestate laws of succession under, under heirship
Mm-hmm.
laws. Um, if it is reasonably minor, then and it can be deducted from what someone can anticipate getting as an inheritance, I'd say it's okay, but what you would need to do is you would need to file. There's usually, if you're in probate court, there's documentation that you would want to file with the court that says, acknowledgement of advanced distribution, and it's very, very specific, X amount of cash. Very often we see this with vehicles, right?
Mm-hmm.
We're going to get a
Mm-hmm.
vehicle, and we're going to get the value assessed, and somebody's going to sign that they got this vehicle. They're going to go transfer the title, and then we will take that assessment and assess it against whatever it is that they might be entitled to inherit. And if for some reason the vehicle would be worth more than their share of the estate, then they either may be asked to waive, or they may be asked to pay the difference back to the estate.
Okay. And it's interesting because I would assume that question came from someone, a family member who's waiting to get their money. The
Yep,
other side of that coin is the personal representative who might be worried, up all night, worried that they missed something or there's an expense that might pop up or taxes or
sure.
something else coming. And so that's I like your advice. I like your advice on that one.
Yeah.
The next question we have involves surviving spouse. And the question is, actually, I'm going to deviate from the question just a little bit because it's very vague. But one of the questions we get a lot when there's a surviving spouse and also there are children from a previous relationship, and maybe the surviving spouse does not have their name on the deed. Um, what should that surviving spouse do to protect themselves from maybe other, well, basically
I think you
stepchild?
faded out there. They don't
Oh,
have their name on the deed or on a bank account or.
so the question, I'm sorry, well, why don't I just read the question the way they asked it?
Okay. What can a
It's very,
surviving spouse do to protect their interests?
yeah, how can a surviving spouse protect their interest in a home when there is no will, and especially when there are children from previous relationships?
Okay. Well, there can only be one surviving spouse. We know this. And in Minnesota, there is a spousal guarantee.
Okay.
And so, a certain amount of, and if there's no will, so I'm just gonna game this out. I'm just gonna
Hmm.
have to think about this. If we have a
That's what I was
deceit.
trying to do, Kate.
Right, I'm sitting here thinking thinking through this is, in lawyer world, we call this an exam question, right? Because in law school, we are given a fact pattern and we
Hmm.
have to pull out the issues and place things appropriately. So if we have an intestate spouse who is deceased and we leave a surviving spouse, and there are children, but they may or may not be this person's uh, children,
Correct.
but we don't have a will. So we
Yes.
fall back onto the intestate laws of succession, so the Minnesota statutes. And in those statutes, a surviving spouse is guaranteed a certain amount of inheritance or
Mm.
protection based on the laws and rules of the state. So they are entitled to, I believe they're entitled to, if not ownership of life estate in their real estate, so they can't be kicked out of their house, a certain amount of money, I believe a vehicle, tangible personal property, etc. And then the remainder of the estate is distributed per stirpes, which means per the law, and that would go to either the children, parents, surviving spouse, children, parents, siblings, etc. Um, so fear not, a spouse cannot be, a surviving stepmother cannot be, turned out in the cold only to, live in a cardboard box. That's not happening. But that will need to be discussed. It may need to go through probate because there's questions, right? This is where good estate planning comes in.
Yeah, exactly.
Making sure that if and it's very simple. If you own a house together in joint tenancy,
Hmm.
then you inherit that house as a joint tenant. You receive that person's other portion of the house, and you sign an affidavit of survivorship, and that house then becomes yours by law. So that's something that doesn't happen. Likewise, anything that's got beneficiaries on it, make sure that if they have a life insurance policy, that they get a certain percentage of the life insurance, or that they're named as a beneficiary. There are ways to make sure that your kids are taken care of, but that your spouse is also. If there's no will, and those are things that can be done outside a will, right?
Right, right, 100%.
If there is a will, and by the way, there are some situations where spouses can in fact waive their
Mm.
automatic spousal privilege or spousal allotment, but that has to be an affirmative waiving. Like it has to be a written thing. There's a lot of second and third marriages where it happens later in life. Everybody's had their own full financial situation and they do not want to mix funds. So we do a prenup, we would do active estate planning, and we would make sure that it's incredibly clear who owns what and who gets what.
Right. That would, yeah, that is the best way to do it. But one of the
But
other
in the
things,
situation where somebody dies without a will, um, probate court, and everybody would get a notice. There's a notice to surviving spouse and children, and it notifies you of your rights.
absolutely. And the thing that you didn't say, but I was thinking as you were talking about that is probably one of the me as a realtor, what I would recommend for that spouse is make sure you're talking to an attorney like Kate so that your rights are identified and protected, right?
Absolutely.
I've actually come across a few people who just trust they just trust other people to look out for their best interests, and I'm like,
My
so you've
son
been
said he gets everything. Not really.
yep, yep,
Yeah.
the
It is amazing how many armchair lawyers there are out there. Well, I've watched every single episode of LA Law or whatever, or
yep,
Boston Legal.
right. I mean, do the 1 hour, talk to an attorney, make sure even if you assume that what they're telling you is correct, verify it,
And
validate.
it may very well be. It
Right,
may
right.
very well be, or the other thing that I love, I'm sure you get this too. Um, Part of what I do in my practice is I fully intend to be a full resource for my clients. I have a tremendous referral network that I very intentionally build. If we
Mm-hmm.
have an estate property that I know we're going to need a realtor for, I'm going to look at my list and go, okay, I'm going to give you 3 or 4 names, but these are people that are well vetted and who understand what they're talking about, right? So I want to do that for my clients. You have no idea how many times I go, okay, so if we're selling the property, have you talked to a realtor yet? Have you gotten a market analysis? Do you know? Oh yeah, my cousin's a realtor. He said
Mm-hmm.
he would do it for me.
Yep,
Okay, the property is in Woodbury and your
yep.
cousin is based out of Pine Island, right? Or
Mm-hmm.
Cannon Falls.
Mm-hmm.
Doesn't know the area, doesn't, in that situation, I'm like, okay, well, maybe if your cousin works for Remax, they can partner with a local, or I can find someone within Remax that's in the Woodbury, in that area or something. Let's make a better match here because just because your cousin said they're going to do it doesn't necessarily mean it's a good idea. And And you shouldn't be doing that just to save the 1.5% commission or whatever it is. Or, they said they would do it for free. I wouldn't do that. I don't want you to work for free. I want you to pay the commission because I want you to get the best possible price and representation for your property.
Yes, absolutely. I worked with I worked with a client who did not have an attorney and chose they insisted on choosing the title company because it was close to their house and they knew the closer. And
We all know the good ones and the ones that you're comfortable with too.
yeah,
That's another thing, like we're perfectly able to pick our own title companies, and I've worked with some that are just fantastic, and I've worked with some that are not as fantastic, and you know who they are.
yep,
But there's title companies that sometimes specify in certain types of property. Like
right.
if you have a business property or something industrial, or if there's something funky, or if they're used to doing a certain type of property, that may very well be that title company that you really need to use.
Well, and before we settled that estate, that client ended up with an attorney who we
Good.
referred him to, and also a different title company. So
Yeah. But likewise, I love it. I love getting calls from my referral partners. And likewise too, I'm happy to give anyone a friendly 15 minutes if it's a quick question or if it's something along that line. Now my phone's gonna be ringing off the hook and say, I have a quick question for you.
yeah, yeah,
Please set up a consultation. But for my referral partners, especially if it's somebody I know and I've worked with a lot, I never mind answering a quick informational, sending a quick email,
right.
getting together. I actually had a mortgage consultant call me from a consult in their office, and they're like, "Hey, I've got clients here and we've got a question. Can you jump on real quick?"
Hmm.
Absolutely. I'm happy to be that resource. I know clean out people, tradespeople, estate sale people. Whatever it takes to get this estate settled is really what we're going to do. And that's the other one other quick question. If you want to talk about why you should hire a lawyer, why you should hire experts, I recently had a case where the decedent had old money judgments, okay,
Mm-hmm.
from old credit card debt long ago. They had been sitting out there and the house wasn't worth much, but so these money judgments were worth a significant chunk of the estate, and the title company discovered them and said, "Well, we can't close until we settle these judgments or we're going to have to pay them out of proceeds." Well, what we ended up doing was I actually ended up taking them to court because they weren't properly recorded against the mortgage, and the title company or the company hadn't they hadn't submitted a claim appropriately. Long story short, we got them dismissed to the tune of probably I think if I recall correctly, it was something of $15,000 I saved that family.
That's amazing. That's
Which
amazing.
in which you would never get if you would never know that you'd have to do that. They might have just said, "Yeah, okay, pay them," and then they'd be out that money.
Well, and when you talk about your list of people that you refer business to, you also
Yeah,
know the good ones and the bad ones, right? Like I also
absolutely.
have a list of the cash buyers we need to stay away
Yeah, I mean, and that's too. I
from.
have
Yeah,
lots of probate properties are distressed. They're as is. They haven't been updated in a while. Um, if you know the investors, it's very, very, and if you know the realtors who have the investors and or who have signed agreements with investors that they're saying, look for properties for me, right? It's very easy to streamline that sale, find a good cash offer, close in 7 to 10 days, everybody's happy, and then you've built a really good relationship and it moves that off the estate and it just moves that estate that much quicker.
absolutely. Kate, we are going to wrap things up. Are there any other parting tips or advice that we covered a lot? Is there anything else
Yeah.
that we should have covered that we didn't?
No, well, I mean, we could probably talk another hour on transfer on death deeds, but
We will.
we'll come back and do that another day, or you can talk to another attorney about that. But I would say this to your viewers and your listeners, don't be afraid to call an attorney. We do not bite. Most of us are extremely compassionate, we're ethical, and we're not trying to gouge you. We're just trying to we have a lot of expertise and we can guide you. We can save you time, we can save you money, and save you hassle. And just like hiring any other service provider, any other expert, we are worth what we're paid, and I think that's important. And also, again, no matter how big or small the estate is, important to go through the business of a person's life and really get an idea of what's there because
Right.
you never know. So, wait 2 weeks after the funeral and then give me a call.
I will vouch for uh the worth of good attorneys, especially in probate. Um I my
I
attorney
liken
saved me
it.
so much time and money and pain and family relationships. It was a
Yeah, Rena, one of the things I'll say is also I love probate because I call it navigation. I don't call it
Mhm.
administration because so I'm a cruise junkie. If I'm on vacation, you'll most likely find me on the deck of a cruise ship. That's my happy place. And the way I say it is this: if we're on the cruise ship of life, you want to be on the Lido deck, enjoying a fruity beverage, watching the world go by, not a care in the world, sun on your back, in the pool, music's moving, right?
Mhm.
You want me up on the captain's bridge at the wheel navigating these waters
Right.
because I've been trained how to avoid the stuff that the bad stuff. I know these waters. I've been here before and I know how to get you through so that you have not a care in the world and all you need to worry about is how you're getting to the next port. And you will get there on time, safe, and you'll have no idea how it happened.
That's right.
But that's me.
Absolutely.
I am your cruise ship captain and I am the one who navigates you through these waters.
That is perfect. And Kate, how would you like our viewers and listeners to contact you?
If you'd like to contact me, you can either go to my website, which is kstlawmn.com, and fill out my contact sheet, or you can email me directly at Kate, which is Kate, at kstlawmn.com. Those are the best ways to reach me for an initial consultation or a question.
And I will include that information in the show notes. And we've been talking with Minnesota attorney Kate Smith-Thompson from KST Law. And Kate, thank you so much for joining us today and sharing tips and insights. And I'm looking forward to having you back again.
I'd love to come back again, Reen. It's been a pleasure. Thank you so much.
Thank you.